All right. Hello, everyone, and welcome to the CAMS Ask the Experts webinar. I'm Kathy Johnston-Pittman. I'm the CAMS Director of Professional Development. I'll serve as your host today. Our webinars that we have monthly are brought together by a team of people. And unfortunately, we lost an instrumental member of that team. On December 20th, Susan Roundson passed away, and we would just like to take a moment to acknowledge Susan. She was a wonderful community manager. She was a wonderful member of our team. She was a fantastic mentor to people on the CAMS team, as well as people throughout North Carolina, Florida, and the country, really, as an outstanding community manager. So we recognize Susan's contribution to our company, to our profession, and to our state. So let's take just one moment, remember Susan, those of us that knew her, and acknowledge her wonderful contribution. Thank you. We are talking today during our monthly Ask the Experts webinar about effective management of community associations for board members. It's presented today by our experts, Mike Hunter Ben Karb of the law firm Kirk, Palmer & Thigpen. Some of you that have participated in our webinars before have had the opportunity to learn from them previously. This webinar, like all of our webinars, are recorded, and you can find them by going to the camsmgt.com website and go to the board member resources page, and you will have the opportunity to see the list of webinars. So feel free to check those out. Ben and Mike, we appreciate your time. Ben and Mike are going to be available for questions at the conclusion of their presentation. So if you have a question for them, just pop them in the Q&A function of the Zoom meeting, and they'll have, if time permits, they'll be able to address your question at the end of the presentation. So we'll turn over to Mike and Ben. Thank you so much for being with us today, gentlemen.
Thank you.
Yep, thanks, Kathy. All right, I'm going to try to share my screen here. All right. Are you all able to see the first slide that says effective management of community associations?
Yes, we are. Thank you.
All right. Well, thank you for the introduction. On behalf of all of us in the HOA community association world, Susan really was a very important member of that world. So we all lost something when she passed away. So it is very sad and a big loss for all of us. It's always hard to follow something like that with a presentation, but we will certainly do our best. We are attorneys with the law firm Kirk Palmer, and the purpose of today's presentation is really to give both a top-down view and a more focused view of HOAs, condominiums, and good practices for governing them. We will address both North and South Carolina. My name is Ben Karb. I'm joined with Mike Hunter. And as mentioned, we'll try to leave time at the end for questions. We will certainly do our best to get through the presentation, but we hopefully will keep you awake. And thanks for being here with us today.
Mm-hmm.
So the first thing any board should really be familiar with is the governing documents for your community. The typical documents are articles of incorporation. That's the document that's filed with the Secretary of State, and that actually forms a nonprofit corporation that is your HOA or condominium. That's really not the most important document, though. Your most important document is your declaration. In South Carolina, for condominiums, it's actually referred to as the master deed. But we may use the terms interchangeably, but it's really your declaration or your master deed. And that is at the very top of the hierarchy. Almost everything important for your community is going to be contained within that document. And then right below that is your bylaws. Your bylaws typically contain information that really governs meetings of the members, or the board meetings. And the bylaws are very important too, but they're not nearly as important as the declaration. Most communities also have rules and regulations. This can be anything from architectural guidelines to your pool and clubhouse rules to a delinquency policy. They are really below the bylaws and the declaration in the hierarchy, but they're also very important. And we think boards should certainly be familiar with those documents. A good board is an informed board, and to do that, a board really needs to read the documents and know what's in them. You don't need to be able to cite them. That's part of what we do as attorneys, but you need to know generally what your documents do. One thing that communities should always be aware of is what the provisions are for calling meetings, both board meetings and membership meetings. If you do that wrong, it can call into question the entire meeting. So Mike, do you have anything to add to this slide?
The only thing I have to add is your bylaws. I refer to those as your corporate playbook, because your HOA is a nonprofit corporation, and every corporation has a set of bylaws. And the bylaws speak to how the corporation functions, who's a member, what the voting rights are, what are the qualifications for, to sit on the board of directors, what are their duties and their authority, et cetera. But in a lot of especially with older condos, we see a lot of bylaws that actually have language in them governing the real estate. For example, a lot of the restrictions on use of the condos appears in the bylaws. That's not how it's done anymore. And in a perfect world, everything having to do with the use of the real estate should be in the declaration, and the bylaws should be strictly a corporate document. But I just want to alert you all to that. Sometimes in older documents, you'll see things mixed up a little bit.
Yeah, that's a good point. And another point is that people always refer to their documents as bylaws. Well, what do our bylaws say? And usually that's not correct. Usually they mean, what does our declaration say, or what does our master deed say? So something that boards should do but don't always do is they oftentimes won't have complete copies of their documents. It's not rare for us to find a board that says, well, here's our declaration. And we say, well, what about the legal description at the end? Or what about the bylaws that were attached to it? And it's something that is easy to overlook, but boards should make sure they've got all their documents. And going hand in hand with that is, are your documents current? A lot of documents for HOAs were drafted in the late 70s, the 80s, the 90s. And as you might imagine, the laws and really society has changed a whole lot since then. Boards should periodically take a look at their documents and in consultation with their property manager and with their attorneys, decide if they should be updated. Most of your declarations or master deeds require a 67% vote to amend, so it's not easy to change them, but it's something you should consider periodically. One thing we also see is that the registered agent may be the original developer or the original developer's attorney. The registered agent is someone who is required to be appointed at the Secretary of State level, and that person's sole job is to get very important communications, lawsuits. Notice that the corporation has been suspended by the Secretary of State. Things that really are very vital to your community, but you'd be surprised how few communities take the time to just double check that information. Do you have anything, Mike?
Nope, nothing to add.
So we'll take a dive here into annual meetings. We'll discuss both North and South Carolina meetings, which are certainly a little different for each state. Here is a summary of what we'll go over. We'll just talk about general topics, quorum, proxies, ballots. We will talk about the election and, unfortunately, the removal of directors and officers, and then we'll talk about the budget. So, as we already touched, really your bylaws are important for meetings. Most of the year, your bylaws collect dust, but when it comes time for your board meetings on occasion, and definitely your annual meeting or your special meetings, you really need to be familiar with your bylaws and work with your property manager and your attorneys to make sure that notice is proper. You usually have to send a minimum amount of notice, and it can't be more than a maximum. The typical bylaws say no more than 10, no more than 60 days. So if you fall outside of those windows, your notice may be invalid. Your bylaws also say what the quorum is. The quorum is just the minimum number of people that have to attend the meeting to be a valid meeting. For some older communities, it may be 20% or as high as 50%, on occasion even higher. As most of those in attendance know, it's hard to get 10% of people to show up at a meeting, but you need to know what the quorum is, because if you don't reach your quorum, it's not even a meeting. You basically haven't accomplished anything if you don't attain the quorum. In North Carolina, not in South Carolina, but in North Carolina, the legislature has updated the laws effective around July of last year, or well, 2021 at this point, actually, to allow annual meetings and special meetings to be held electronically. And importantly, they also enabled voting to occur electronically. It's still a very new concept, but historically that was not permissible. Now you can do it. So that's sort of a huge change in the HOA world and something that we're all getting used to, but hopefully it'll increase attendance and it'll make meetings more accessible. South Carolina has no such law. Your documents may allow it, but the law by default does not allow it. So South Carolina is kind of out there on an island, at least compared to North Carolina. You also have some options to vote outside of a meeting. The technical term is voting by a written ballot in lieu of a meeting. And what you have to do is send a ballot to everybody. Everybody who would be entitled to notice of the annual meeting gets a ballot and gets a chance to vote for or against what you're voting on. And your ballot has to be submitted by a certain date. So that's also a possibility if you're not able to have a meeting, or if circumstances make it a better option than holding a meeting. In North Carolina, not in South Carolina, Robert's Rules of Order applies to all HOA meetings. It's a statutory requirement. I hope most of you have never encountered Robert's Rules because it's not exactly fun reading, but it's basically a playbook to hold a meeting and what can take place at the meeting and what cannot. A lot of it is somewhat archaic at this point, but it's helpful in some meetings, and it's helpful to at least have a basic knowledge of it. It's something you should consider discussing with your manager and your attorney to see how it can help you hold meetings. South Carolina, it's whatever goes. If your document, or whatever your documents say, if your documents say that Robert's Rules applies, then Robert's Rules applies. If your documents are silent, well, you as a community can decide how to conduct meetings, and you could probably adopt Robert's Rules, but it's not required. Anything to add, Mike?
Yeah, on the quorum, we've had a number of clients over the years whose bylaws have a very high quorum requirement. I've seen them 50%. I've seen them as high as 75%. And a lot of times those communities, they can't ever hold board elections because they can't get enough people to show up at the meeting to meet their quorum requirements. So obviously the one thing you can do is to propose an amendment to the bylaws to reduce that quorum requirement. But of course, you still have to get that 50 or 75% to show up to vote on that amendment to the bylaws. But another concern a lot of them have is a misconception that when the directors reach the end of their term and there's not enough people at the annual meeting to elect a new board, that the board goes away and there is no board. In other words, their terms expire when they expire. Fortunately, the North Carolina Nonprofit Corporation Act, it says that a board member will continue to serve as a member, as a director, until his successor is elected. So I've had probably half a dozen clients over the years that have gone literally years without being able to reach quorum. And the board members, they largely stay the same because the volunteers are willing to stay on. And if someone resigns or moves away, they appoint someone to fill that vacancy. That's not the best way to handle things, but sometimes their hands are tied because they just can't get people to show up for the meetings. And a lot of times, if you have trouble getting people to show up at your annual meetings, that's almost a good sign, because that means people are generally happy with the way things are running and they're apathetic. When things are controversial or there's some big dispute in the neighborhood and people are angry with the board or something, that's when you're going to meet quorum, because people are going to show up for those meetings. So, but a lot of times we find that in terms of getting things passed, amendments to bylaws, amendments to declarations, it's not necessarily the opposition. The homeowners are not opposed to what's being proposed, but it's just apathy that makes it difficult for these communities to reach the number of votes they need to make these amendments to their governing documents.
Yeah, and just for our South Carolina viewers, South Carolina has a similar requirement or similar provision that says that a director serves until the director's successor is appointed or elected. So that's something that's very similar with each state's laws. So proxies are something that are often misunderstood by HOAs and members. Proxies are not required, although sometimes owners think they are. But many communities choose to send proxies with their meeting notices. What a proxy is just a form that appoints somebody to attend the meeting in an owner's absence. One thing that owners often confuse proxies with are what are known as directed proxies, that are my last bullet point on here. A directed proxy is actually a document that appoints someone to attend the meeting and it directs that person how to vote. That's the directed part of it. But your standard boilerplate proxy just says, if I'm not able to attend, you are able to attend in my absence, and you can vote however you want. So that's what a proxy is in its most basic, simplest form. And the laws are actually pretty lax on what it takes to be a valid proxy. Proxies now can be an electronic format as long as it has something that shows the person appointing the proxy signed it. And by signature electronically, it could really be as simple as signing your name at the bottom of an email. This is sent by Ben Karb. That would probably be sufficient. You can also, in some cases, appoint a proxy by telephone. So the law really looks favorably on proxies because we want to encourage people or their designees to attend meetings. We want to be able to hold meetings. What a proxy does also is it allows you to reach quorum. Every single person who is attending by proxy counts towards the quorum. So that allows us to actually hold meetings when we otherwise could not. And also the proxy is effective when received. That's not usually a huge issue, but sometimes you get into issues where someone will say they sent a proxy, but no one actually obtained it. Arguably, you could say that by the unless you receive it, there's no proxy. So again, that doesn't arise much, but it occasionally arises. Do you have anything to add, Mike?
Nope.
All right. So this is usually one of the most important topics that people are concerned with. I'm assuming most people attending are on their boards, so you've probably gone through this. Typically at the annual meeting, although occasionally in other settings, such as a special meeting, the members will elect people to sit on the board. In almost every HOA or condo, it's really those people who get the most votes. There's some weird voting requirements in some older condos and HOAs, but typically it's just those who get the most votes. And the one common misconception is that members often think they are voting for the officers. It's pretty common for people to say, well, we voted for our president. Well, I was elected by the members as vice president. Well, that's actually incorrect. Members elect the board of directors. the board of directors then selects the officers. And your officers, your president, vice president, secretary, treasurer, vice secretary. You could have any number of officers, but the officers are chosen by the board. The members do not elect the officers. It's something that members just really don't understand, but that's really how it works in the HOA world. And whoops, I jumped a slide ahead, but did you have anything to add on that last slide, Mike?
No, but that's a good point to make about officers versus directors. There's a lot of confusion. And just last week, I had a client that was, for years, they've been under the impression that they were electing officers, that the members were electing officers, and I had to educate them on that. But yeah, it's happens occasionally, but not too often.
All right. Unfortunately, directors can be removed. When this usually happens, it's usually because of some major controversy. Sometimes it's because members perceive that the budget goes up too much, or they perceive wrongdoing. On occasion, it's probably warranted. Sometimes you have directors that really aren't doing a good job. But to remove directors, there's a very specific process, thankfully. Thankfully for those on boards and for us as attorneys, because usually it's done improperly. You'll get one owner who sends an email and says, I demand that the board be removed. And you say, well, that's not technically the process, so the board is not removed. But what the process is that someone has to usually request a meeting, and then if they do it properly, a meeting notice has to go out to all the members. And in that meeting notice, it has to say that one of the purposes of the meeting is to remove the board. And at least a quorum has to show up to actually remove the board. As we've already touched on, since many owners are apathetic, sometimes you'll get just a handful of owners who can force a meeting, but not enough people show up to actually remove the board, which in many cases shows that it's really just a handful of owners that are unhappy. So contrast this with officers. Since officers are appointed by the board by a majority vote can remove an officer. This isn't all that common, but it does happen sometimes. Sometimes you'll get someone who's the president, for example, who just refuses to listen to his or her colleagues and is doing things without the vote of the entire board. So sometimes the board has to vote to replace the president with someone else, for example. There's also usually a provision in the bylaws which says that if a director misses a certain number of meetings, usually consecutively, then the director can be removed by a majority vote of the board. And the reason for that is you want your directors participating. You really can't be a good director if you're just absent all the time. So that's something that some bylaws have, not all do, but it's helpful to have on occasion. Do you have anything to add, Mike?
Yeah, on the when you have some members who are requesting the calling of a special meeting, and more often than not, they're wanting to vote to remove some of the board members. I've seen cases where a homeowner has gone around and circulated a petition and gotten signatures for whatever percentage of owners the bylaws require to call a special meeting, and these owners, they're picking the meeting date and the time and the place and all that, but that's not how it works. The way it works is the owners petition for a special meeting, but then once they get enough signatures, it's the board that schedules the meeting. It's not the homeowners. And that's a minor distinction, but it's one that just here again, it came up with me just in the last few weeks.
Yeah, that's a good point. Oh, and South Carolina distinctions. The laws are fairly similar in South Carolina. One good thing, at least for us HOA attorneys, is the North and South Carolina nonprofit corporation acts are almost identical. There's a few minor distinctions, but they're really almost the same in most important aspects. So at least for me, I don't have to learn two sets of statutes. All right. in many communities, and I'm sure as many of your managers will tell you, the bane of many communities is the budget. The budget takes a long time to prepare, a lot of thought. Owners are always mad if the budget goes up, but it's necessary in all HOAs and condos. In North Carolina, for HOAs that were formed in 1999 or later, and for all condos, there is a ratification process. And it's actually a bit of a misnomer. It's not really a ratification. It's really a rejection. What the law says is that at least half of all owners have to show up at a budget ratification meeting, or budget rejection meeting would really be the accurate way to term it, but at least half of all owners or any larger percentage specified in the declaration, they have to show up and reject the budget. So in other words, if you have less than half of your community even show up to the meeting, the budget is automatically ratified. A weird quirk for HOAs that were formed before 1999 is that they do not have to go through the budget ratification process unless their documents require it. In South Carolina, there is no budget ratification process at all unless the documents require it. So this is mostly a North Carolina process, although a lot of HOAs have similar language in their documents to allow members to have a say in the budget. And one thing that it may also be on a following slide, but the budget notice, or the notice that goes to members, at least in North Carolina, has to remind owners that the budget can be ratified without even a quorum being present. That's one of the weird distinctions about the budget, that you don't even have to have a quorum. You may not be able to hold your annual meeting because you can't get a quorum, but your budget gets ratified. So that's a unique distinction with the budget that's really not present for anything else with an HOA or a condo. And there's also a requirement that the budget ratification meeting must be held within 30 days after adoption of the budget. So that's just something to be aware of. You can't send the budget out and then dawdle for 3 months and then hold your meeting. Otherwise, you'd have to send out a new budget and go through the process again. Mike, do you have anything?
Yeah, so Ben makes a good point. This ratification process is really a misnomer, because it's not ratification of the budget. You're voting on rejection of the budget, and that really confuses a lot of people. But the reason it was set up this way, which is the budget is ratified by default unless a majority of all owners vote to reject it. The reason it was set up that way is because of the apathy that we've already discussed. If you had to have a quorum of members to appear for a budget ratification meeting and vote to approve it, probably 3/4 of the associations would never be able to get a budget ratified. So the legislature, in their infinite wisdom, when they drafted these statutes, they made it ratification by default. It requires a majority vote to reject it, so the HOA can get on with its business. And I think that's good drafting.
Yeah, I agree with that. And one thing that does come up is what happens if the budget gets rejected? Mm-hmm. Well, thankfully, the legislature was also on top of things there. They say that if the budget gets rejected, the last ratified budget remains in effect. So it's not as if you have no budget. It's just you go back to what was in effect for the previous year. Yeah, so I already touched on South Carolina. There's no statutory process. All right. Additional budget topics, since this is so important and vital to the operation of every community. We also touched on a lot of these. One thing that many communities do, but not all, is they combine the annual meeting with this budget ratification meeting. It just makes sense to do both at the same time. But as I touched on, you may not be able to hold your annual meeting if you don't get a quorum, but your budget gets ratified. So you at least get something accomplished if you do it that way. And one thing that your community manager should be aware of, but you should also discuss in more detail, is to include anticipated capital expenditures. You don't want to leave anything out of the budget, because it's expensive to redo the budget, and you're going to have angry members if they're being asked in a single year to approve multiple budgets. But the law does allow boards to redo the budget if they need to, but you always want to try to anticipate it on the front end so that you're not going back to members on the back end. And most communities also do this, but occasionally they don't, is that they don't have an allowance for bad debt. In almost all communities, you're going to have some member that doesn't pay. Thankfully, in many communities, it's a very small percentage, but you can't assume that 100% of owners are going to pay. And if your budget makes that assumption and even one member doesn't pay, all of a sudden you're not complying with your budget, and that presents a hardship. So make sure you have some sort of allowance for bad debt.
Yeah, and touching back on the budget ratification for capital expenditures, that's like, for example, if you're going to if the board wants to take $50,000 out of the reserve account to build a playground, that needs to be disclosed in the budget ratification process. Now, that's not part of your operating budget. That would be a separate capital expenditure budget. And I've seen boards get in trouble when they made those decisions to expend reserve funds on improvements or replacements. And it was never, technically, if you look at the bylaws and the CCRs, it doesn't say those expenditures require a vote of the owners, but it's really a budgetary thing, and it really should be put out there for budget ratification, just like your operating budget. And back on the apathy thing, as we said, the budget is ratified automatically unless a majority appear to vote against it. So I often jokingly tell my clients, if you want to be sure your budget is ratified, call your budget ratification meeting for 7 a.m. on a Sunday morning. No one will show up. And even if no one shows up, boom, your budget's ratified.
All right. Now we'll get into the nitty-gritty of board meetings. Your annual meeting is certainly important, but really where the work gets done is at your board meetings. In North Carolina, the statutes say that the board needs to hold at least a portion of the meeting open to the membership at regular intervals. And the intent is that members can show up and voice their concerns. That does not mean that members get to take the meeting over. The board can place restrictions on what the members can talk about, how long they can speak. One thing that boards prefer to do is to require owners who want to speak to give their name in advance of the meeting, and sometimes give a summary of what they want to address the board about. The other thing is, it doesn't require the board to take up those concerns at the meeting. The board just has to listen. So it's always a good idea to get your members' opinions. You may not always like them, and members sometimes come in angry and, with the proverbial pitchforks, but you always want to take your members' opinions into consideration, because that's what being a good board member requires. Boards should also give notice of when their board meetings are taking place. Some boards are not very good about this. They reason that since they only have to let members attend meetings at regular intervals, which is probably quarterly, that they don't really have to tell owners when they're even having meetings. But that's very bad practice. You should let members know that you are holding board meetings and when they are occurring. Again, you don't have to let members attend all of those meetings, but you should at least let members know that you are meeting as a board. Whoops. Did you have anything to add to this slide, Mike, before we jump ahead?
Well, yeah, and we'll talk about this a little later, but one of the biggest complaints that we see coming from homeowners about their HOAs is, oh, our board operates in secret. We have no idea what they're doing at these meetings. We don't know where our money's going. And that's why I have some HOAs that they make every one of their board meetings open, except when they have to go into an executive session. I don't think that's necessary, but a lot of them don't realize that the law requires them to hold open meetings periodically. And again, the statute doesn't say what regular intervals is, but Ben and our sort of rule of thumb is at least quarterly.
Yeah, and South Carolina does not have a regular interval requirement, but South Carolina HOAs should certainly adopt a similar practice. All right, these are some things that occasionally come up as questions to us. but they're things that all boards need to be aware of. You can vote by, or you can appoint proxies to your membership meetings. Board members cannot do that under most circumstances. I don't think I've ever seen bylaws that say you can appoint a proxy as a board member, but some certainly have said that. I don't think I've encountered it. But really, you're elected to the board to attend meetings and make decisions. And for that reason, the law really discourages board members from having someone else attend in their absence. Boards also have special privileges to hold meetings electronically or by phone much more easily than at a membership meeting. A board meeting, it can be held by phone, it can be held by Zoom, it can be held in person. Really, the only requirement is that members get notice far enough in advance, and most board meetings only require 2 or 3 days advance notice, and all directors just need to be able to hear and to be heard. So meetings by phone are perfectly fine. If you've got a controversial, urgent topic, send a text to everybody and say, hey, we need to jump on a call, please get on this call. If all your directors jump on the call instantaneously, you've met the notice requirement. So it's fairly easy to hold a board meeting, but you need to do it. And one thing that I will say is incorrectly done by many, many, many HOAs in North and South Carolina, but we see it all the time. If you are taking action outside of a meeting, and this is typically by email, you need unanimous consent. And unanimous means unanimous. If you've got 5 directors, you need all 5 to say, yes, we agree. If you've got 4 saying yes and 1 person is silent, that is not effective. So you really cannot vote by majority decision by email or outside of a meeting unless everybody votes the same way. Do you have anything to add before I jump to the next slide, Mike?
No, but I'm curious, does South Carolina have anything similar about action taken outside of a meeting?
It does. It is identical. So really boards should not, boards should not vote by, majority vote by email. They really need to do unanimous.
Yeah, we have lots of clients that are unaware of this, and then they take actions all the time just by circulating emails among each other. And today with Zoom and Microsoft Teams, it's so easy to schedule a conference call or a Zoom meeting on short notice. And if you do that, you only need a majority vote. You don't need unanimous, because those electronic meetings are just as valid as if you were all sitting in the same room together.
All right, so a few more topics. I think we've already touched on these, so I'm just going to jump ahead. We'll talk about confidential matters. And this is also something that boards get wrong, and when they get wrong and a lawsuit arises, they can sometimes find themselves in very hot water. Boards can and should discuss confidential issues behind closed doors. We refer to that as an executive session. And really, it should be limited to things like collections, possible litigation, contract discussions, personnel decisions. It should not be used as a forum to discuss something that just may be objectionable to the community. For example, if the board is discussing whether the budget needs to be raised in a given year, that's not really something that should be discussed behind closed doors. One thing that we will touch on in more detail is the attorney-client privilege. I'm not going to get into detail, but that is one thing that is confidential. One thing that is not confidential, and that boards often are sadly mistaken about, is that communications between board members are not confidential. And what we mean by this is sort of 2 things. One is, let's say me and Mike are on a 3-person board, and Mike and I are sitting there emailing each other saying, gosh, this homeowner's a real jerk. We're going to let this guy have it. For one, that is not even a protected communication under any circumstances, because it is not at a board meeting, nor does it even, in my example, we didn't even copy the 3rd board member. So that's certainly not official board action. If you could even consider it to be executive session, we excluded one of the directors, so it doesn't even get protected anyway. Now, it may be protected under some sort of fair debt laws, but it's still very bad practice. And if a lawsuit were filed, that gets disclosed. The other thing is sort of what I touched on earlier. Board member discussions in many cases, even if they're controversial topics, they are not confidential. If it is something that is undesirable to speak about, that doesn't necessarily mean you can withhold it from owners. So you should be aware of that distinction. We'll talk a little bit more about this, but Mike, did you want to touch on anything before I jump ahead?
No, I think you covered it.
All right, meeting minutes. Meeting minutes are vital because that's the record of what happens at meetings. But most communities get this wrong, or at least they don't do it the best way, in my opinion. Meeting minutes are a chore, no matter how you look at it. But most boards include so much more information than they need to. The meeting minutes really only need to say what was done at the meeting. We don't really care who said what or who made a motion, who seconded that motion under most circumstances. We really care what was decided. Did the board approve a contract? Did the board authorize CAMS to spend $2,000 to plant new bushes? We care about things like that. We don't care who said, well, I don't like bushes. I think we should do mulch. We don't care about that because that's not what was decided. Another thing that many communities get wrong is that you should keep minutes for executive session. Some communities think that if you're going into executive session to discuss something that is confidential, a contract or personnel, things like that, that no minutes have to be taken at all. That's not true. What you should do is have an executive session minute book, which is essentially minutes, but they're kept essentially under lock and key. They don't get disclosed under almost any circumstance unless required by a court order. But you still should have meetings to reflect what was decided, even though it's not readily accessible. You want to add anything, Mike?
No, I don't think you're good.
All right, attorney-client privilege. The law says that we as attorneys cannot give very good advice unless our communications with our clients are not discoverable in lawsuits. We cannot advise clients if we anticipate that the other side can get what we say. That's essentially giving up our playbook. The law protects our discussions with boards, but the privilege is lost if our communications with the board are disclosed. That could be as inadvertent as forwarding an email that we emailed our client on. That we'll talk about emails in a minute, but we are protected and our boards are protected from having those discussions disclosed in a lawsuit. Do you want to add anything to that, Mike?
Yeah, the moral of the story is loose lips sink ships. Which was a saying, for those who don't know, that was a saying from World War II. But yeah, that's really important. And it could be something as innocent as just a board member going home after a board meeting and discussing a confidential matter with their spouse. So, I mean, that potentially could sever the attorney-client privilege. But the most common one we see is where there's an email chain between the board and the HOA's attorney, and the board member forwards that email to someone outside the board. Congratulations, you've just severed the privilege.
Yeah, and on occasion, we'll see someone somehow get the opposing attorney's email address and send the entire communication to the opposing attorney. So
yeah, we've seen that happen too.
Yes, that is a disaster. Do not do that. So we don't need to go into a ton of detail about HOA records, but owners are entitled to certain records automatically. They may be required to pay for them in some instances, but they're entitled to the income statement and the balance sheet. That's the case in North Carolina and South Carolina. In North Carolina, the law says within 75 days after the end of the HOA's fiscal year that those documents must be available to the members, and that's free of charge. Most other records owners have to pay for. There are a lot of other records that people request. Things that you frequently see are receipts or copies of all the vendor contracts or copies of the contract with the HOA's attorney. Under most circumstances, you don't have to provide those, or if you do, You can, one, charge the owner for the cost to produce them. That would be CAM's hourly rate to do that. Or you can impose strict requirements, such as requiring somebody to sign a non-disclosure agreement. So I'm just going to flip ahead to the next slide, since we dive into deeper detail. To get most of these records, a member has to meet certain requirements. The request has to be in good faith and for a proper purpose. We really don't have a whole lot of law on what good faith or a proper purpose is, but you sort of have to look at the homeowner's conduct in general. If a homeowner's been sending emails to legislators all over the state and threatening all kinds of lawsuits and things like that, it's you're shifting towards a bad faith purpose, because they're probably going to be using those records in a way that really is not permissible. They may send a copy of, communications to all owners to their legislator, things like that really is not a proper purpose. A member also needs to describe what they're asking for. Sometimes a member will say, I want all the association's books. Well, that doesn't really mean anything. So they need to be more specific. And the records have to be connected to the purpose for which they're requesting them. That sometimes you just see someone who's going on a fishing expedition. They want every record, but they don't say why. And that providing no purpose doesn't mean that you have to provide anything other than certain records that you have to provide, such as copies of your declaration, your membership minutes, things like that. But if they don't have a proper purpose, you oftentimes don't have to disclose anything.
Yeah, and the statute does detail which records they're entitled to, but even those records, they still have to identify a good faith purpose and exactly what records they want and how those records are connected with that purpose. But we do occasionally see what we call the kitchen sink request or the fishing expedition, where it's usually a disgruntled homeowner who has an axe to grind with the board or has a personal agenda or personal vendetta they're pursuing. Will send a request saying, I want to see all of the records of the association going back 10 years without being real specific. And a lot of times, number one, we reply to them and say, well, look, here's what the statute says you're entitled to. And we'd be happy to provide those to you. And then when they find out they have to pay for the cost of CAMS's staff to go pull these records and copy them, a lot of times they'll go away.
Yeah. So we are about to jump into email communications. These are more good practices. A lot of these seem like they are self-explanatory, but you would be surprised how many times we have seen it go horribly awry. Communicating by email is good. Everybody does it now. But if you forward an email, be careful where it goes. It is not unthinkable that if someone says something that could be slanderous in an email, and then you forward that email somewhere else, and what sometimes happens is a board will get a nasty email, and they'll try to be transparent, and they'll reply to the email, but maybe copy the entire community. But if that email has something in there that's confidential or slanderous, they have then potentially exposed themselves to a libel lawsuit. If you forward something that is untrue and could come back to hurt you, you could be sued and you might lose. So be careful about replying all. Be careful where your emails go. Don't forward the attorney's email to anyone outside of the board. A good point is once you send it, you can't get it back. There's an electronic record always. You may not realize that, but there is always an electronic record. If you send it, someone can find it. And that goes with deleting emails. If you delete an email, there is still an electronic record. If you delete it from your computer, there is a forensic analyst out there who can retrieve that email. So you need to be professional at all times. Most boards need to take the view that if I write it, it might wind up in front of a judge. And that's something that every board should be aware of. If you would be embarrassed with your email getting read to a judge or a jury, you need to rethink it before you send it. So we can't caution that enough. Emails are the things that get boards sued, and they can cause boards to lose. So be very careful with email. Do you want to add to that, Mike?
No, huh? We're short on time. The next three slides are just comic relief, so we can skip over those. Just sharing some of the crazy things we've seen in our years of doing this.
Yeah, well, and this one's very funny. It talks about, I shouldn't say funny, terrifying in many respects. It was an owner who apparently brought a gun to one of the meetings you attended, Mike.
A board meeting who brought his handgun to the board meeting and slapped it down on the table.
As his peacemaker.
Yeah, his peacemaker. Mm-hmm.
We've touched on some of these concepts, but secrecy breeds suspicion and contempt. The biggest complaint owners have is that boards aren't operating transparently. That's usually not true, but members just think that. So allow members to attend meetings. They'll usually fall asleep and never attend a meeting again, but invite members to attend board meetings. Keep your property manager in the loop. I'm sure CAMS will tell you many times that their boards will communicate with us or with a vendor or with an owner, and the manager may be the last one to find out. That's not good practice. Don't let owners hijack meetings. I talked about Robert's rules earlier. I'm not going to go too deep into that, but there are certain techniques that you can adopt to control what owners say and do at meetings, such as limiting the amount of time they can speak, or requiring every owner to have the opportunity to speak before an owner gets a second opportunity to speak, so that you don't have one owner who asks 50 questions. Talk to your manager or your attorney if you're finding trouble holding meetings. You have anything to add, Mike?
No, you're good.
All right. So violation and delinquency policies. Some communities have these, some don't, but it's always a good idea to have one, we think. But if you have a policy, follow it. If you say that you're going to send an owner to the HOA's attorney after 90 days, but you don't follow that policy, then that's essentially discrimination. If you treat one owner according to the policy and one owner you don't, you now have treated both owners differently and you've discriminated against one owner. So if you have a policy, follow it. We also talk about self-help. That is something that should be rarely used. And by self-help, we're talking about going onto an owner's property in most circumstances and fixing something. That is a surefire way to potentially get sued, but you can also increase the risk that someone intervenes and gets hurt. You sometimes have to get the sheriff involved. It should be a last resort. Some communities have the right to do it, but talk to your attorney before doing it because it's very risky. You should avoid doing it on your own.
And in general, there's nothing in the Planned Community Act that allows HOAs to enter onto someone's lot and, for example, remove a fence or a shed that was constructed without approval of the architectural committee. But it's one thing to go on someone's lot and pick up trash or roll their trash can back to behind the garage or whatever. But going in and ripping out landscaping that they've installed or hardscape or removing fences and sheds that were installed in violation, that's not something you want to do. And the next screen is like, if all else doesn't work with curing violations, you can always next screen bit. You can always bring in the A-team. They'll take care of the job for you for a price. I'm probably showing my age with this slide because a lot of people out there, I imagine, don't know who this is or remember the A-team series from the early 80s.
Well, I remember it well. So we sort of touched on this. If you've got a delinquency policy, follow it. But don't be afraid to foreclose. And that sounds harsh in some respects, but your community, if you are on a board, you owe your community a fiduciary duty to collect money from members who don't pay. That doesn't necessarily mean that you need to act hastily, but you have certain tools in your toolbox to collect against owners, one of which is to foreclose. It is usually the quickest, most cost-effective, and most likely way to recover money is to foreclose. Treat everyone equal. Be willing to enter repayment plans. You can usually charge an owner for the cost to enter the repayment plan, for our fees or for administrative costs on your property management side, things like that. But it's also another tool to consider. We also do not usually advise board members to communicate with owners who are in collections. Part of the reason that we are hired and paid is so that boards don't have to deal with owners. Obviously, an owner's debt is very personal to that owner, and we don't want to put a board member in harm's way or have the board member say something they shouldn't. There are very strict laws that govern what can be said to owners, so boards are usually not fully up to speed on those laws, so we usually say to have your attorney communicate with the owner.
Yeah, and let me reiterate about your delinquency and your violation policies, about how they should be enforced consistently and uniformly. Ben makes the point that if you don't do that, if the person is a member of a protected class under the FHA housing non-discrimination housing guidelines, you could be faced with a housing discrimination complaint. Or if not that, I mean, you could be accused of enforcing the rules or enforcing collection practices arbitrarily and capriciously. The person who lives next door to the president is 8 months behind in his dues. He didn't have a lien filed. And that's the problem you run into. You don't play favorites. Just be consistent and uniform. And we're not saying you can never grant exceptions or waivers. You can't. You should have the authority to do that in exceptional circumstances. But as a general rule, you should try to be very consistent in how you apply these policies.
Yeah. So I'm only going to touch on this slide for a second. Typically, in most communities, what we don't have on here is that there's a pre-lien letter in North Carolina that has to be sent to an owner that tells an owner, if you don't pay in 15 days, your account's getting sent to our attorney, and the attorney's fees are mandatory. South Carolina does not have a comparable requirement unless it is built into the documents. But once it comes to our office, we file a lien. That lien can be foreclosed. Obviously, that's an extreme remedy, but it's out there, and boards need to know when they need to use it. We attend the foreclosure hearing. Usually no one else from the board has to attend, and unless it's contested. Then there's a foreclosure sale, and then the property goes to auction. It's really quite simple in concept, and in both North and South Carolina, it's almost shockingly easy to foreclose for an HOA debt. Did you want to add anything to that, Mike? Or
no? Again, we're about to run out of time here. We're going to have to end here in a few minutes, and then Ben and I will hang around until 5:45 and take questions. But just want to keep everybody on schedule here.
Yeah, and that's me before I go into court, in case you didn't recognize. All right, so get a copy of Robert's Rules of Order if you're in North Carolina. There's some helpful tips. We can certainly advise boards on ways to help their meetings go well. Ask if you don't know an answer. Your community managers are a great resource for things they don't know. They should be willing to say, well, we need a legal opinion on that. You come to your attorney. You as board members are not expected to know everything, so you need to ask. Be careful what you tell owners. They are looking to you as the board of directors. They often don't recognize that one board member really cannot speak on behalf of the whole board, but you can be assured that if you say something that they like or maybe even don't like, they will bring that out and say, well, I thought the board said I could do this. So be very careful about that. Communication with your members is critical. That goes to the whole transparency thing. If your members feel like they're getting regular communications and that they know what's going on, those are happy members. So do that regularly. Keep members informed. Anything to add, Mike, or should we move to the last slide?
No, I think that's good. Yes. Again, secrecy just breeds suspicion and contempt in your members. And that's the biggest complaint we hear from homeowners is our board operates in secret. So communication is essential.
Yeah. So I guess second to last slide, we've got a blog. Mike started it. There's many blog posts going back many years. It's very helpful. Feel free to read it. We've got a new blog post that'll be coming up probably this week on a recent North Carolina case. We also cover some South Carolina cases. So it's a good resource if you have questions.
Yeah, and I noticed the URL on this slide is wrong. It's actually just carolinacommonelements.com. You don't need the WordPress. And if you go to that site and you subscribe, you'll get an email every time we post a new article. And no, we don't sell your emails. No, we're not going to bombard you with marketing emails. The only emails you'll get is when we post a new article.
All right, we made it through the slides. Hopefully most of you are still awake, or at least some of you. And why don't we?
You haven't gouged your eyes out yet?
Yeah. So do I need to stop sharing my screen, or what do I need? You can leave
that up there. That's perfect. We can see your contact information. Mike and Ben, thank you so much for that helpful information. It was very valuable. We did get a lot of questions, so we've set aside 15 minutes, but we understand you made a commitment for an hour. Our attendees did, and if you need to leave, please feel free to. But if you're available and can stick around for some of these questions, we've really gotten some good ones today.
Yeah, I glanced through some of the questions. There are some good ones in there.
Yes, there are. So the first question we received, I think it's a good one, is can you share your thoughts on why an HOA attorney specialist can be more helpful than a board member who's an attorney on it?
Absolutely. First of all, if you have a board member who's an attorney, this North Carolina State Bar rules prohibit him from providing legal advice to the HOA because that's a conflict of interest. Because he's a board member and he's also serving as an attorney to the board, he's essentially representing himself. So that is bad news. An attorney who is sitting on the board certainly may have a measure of legal expertise that would be helpful to the board in making decisions, but he should not be giving legal opinions or legal advice or drafting documents or doing other things. Secondly, just because he's an attorney doesn't mean he knows anything about condominium or community association. He may not. I don't know what your situation is, but that's why this is generally not a good idea.
Excellent. Thank you. So another question we got deals with the declarant control period, or when the declaration even expires, right? So we see that happening. What happens, what rules after the declaration period is over, the declaration or the bylaws is the question. So I'm assuming perhaps the declaration has expired. There's not an auto renewal period, is how I'm reading.
Yeah. Most of the documents we see in planned communities say that the declarations are going to be valid for 30 years and then will automatically renew for successive 10-year terms unless they're terminated or modified. So it's just, in other words, it goes on in perpetuity until they're terminated or modified. I have seen some communities that have covenants that were poorly drafted, and they have a hard end date. You know, these covenants are valid for 25 years, period. Well, once you hit that 25 years, those covenants are no longer enforceable. Your HOA no longer has any authority.
Yeah, and for those communities, I have had ones where they will amend it to make it last into perpetuity. But if you miss that deadline, if you catch it too late, then you really arguably have to have 100% of all owners agree to extend it. So that's something communities need to be aware of.
Yeah, the key is catching it early, dealing with it before you reach that expiration date.
Thank you. So as always, we have questions about voting and ballots. That's always a hot topic, isn't it?
Yes.
One of the questions we've gotten is, as to the ballot for the election of directors, the bylaws allow for nominations from the floor at the annual meeting. However, many folks submitted their voting ballots ahead of time. How do we deal with
that's the problem with allowing members to cast their ballots before the meeting.
Yeah.
Robert's rules, and the whole point of this parliamentary process is these meetings are supposed to be a deliberative process where the members can gather, make motions, discuss and debate the issues, and vote with a full exchange of ideas and information. You don't get that when people are sent a ballot a month before the meeting. They fill it out and send it in. That sort of defeats the purpose. But we realize the reality of the situation, and a lot of HOAs, especially during COVID, were doing it this way, and letting owners send in ballots before the meeting. And I had a lot of them just like, we're going to hold our annual meeting virtually, and we're going to require that all the ballots be cast before the meeting so we can announce the results of the meeting. I don't think that's a good way to do it. I would prefer that you hold the meeting, the Zoom meeting. So if there's other nominations from the floor or other business that has come up since the notice of meeting was sent out, it can be discussed, and then owners can mail in their ballots up to 2 weeks or 3 weeks or whatever after the meeting. I think that's the better way to handle it. But if you want to insist on having owners cast or giving them the opportunity to cast ballots before the meeting, your ballot should include a couple of lines on it for owners to write in the names of write-in candidates, which is essentially the equivalent of a nomination from the floor.
Thank you. Ben, do you have anything to add to that?
No, I fully agree with what Mike says. Really, what the purpose of HOAs is to show up at a meeting, hear people speak, and then make a decision. I realize the reality is a lot of HOAs now are doing ballots and things like that, but you make better decisions both as a board and as a community if you hear other opinions, hear what people have to say, take that into account, and then cast your vote. So that's how it's supposed to work.
Yeah. And another thing I often get the question is, well, can we let owners vote by email? In other words, just send an email before the meeting to the board president or the secretary saying, I want Joe and Sam and Susie as directors. Well, there's nothing in the North Carolina Nonprofit Corporation Act that allows voting by email. It allows for the laws that were changed last year allow electronic voting. But if you read the statutes, it's really geared more towards the live Zoom meetings and some of these platforms, such as GoToMeeting or VoteNow.com. There's a couple of others out there that are specifically tailored to HOAs that will actually host your meeting virtually, and they have systems set up to where the owners can cast their votes live during that meeting. That's what the statute was addressed to allow. But in general, owners are not really allowed to skip a meeting, not appoint a proxy, and just send an email saying, this is how I want to vote. Not only that, it should be discouraged here again, because the whole point of a meeting is for the free exchange of ideas and debate.
Thank you. So let's say a community does vote by written ballot in advance and they don't have a quorum return the ballots. Mm-hmm. Is the quorum reduced by half if they send the ballots out again?
Well, that's a good question. When the legislature revised the Planned Community and the Condo Act to allow, I call that the shrinking quorum law, where if you don't have quorum, you adjourn to a later date, and when you reconvene, your quorum is half of what it was the time before, and you keep doing that until you can meet your quorum. It doesn't mention anything about that policy applying to written ballots, and frankly, it probably didn't occur to any of the legislatures when they were drafting that, whether it should apply to voting by written ballot. So I think if you do something by written ballot and you don't get enough of them back by the deadline to meet your quorum requirement, obviously we have to start over with a new ballot, because when that deadline comes, if you're using written ballots, the statute does not allow you to extend that deadline, but you can start with a new ballot and send it in. Whether or not you can reduce your quorum by half, I don't know. I think that's risky because the statute doesn't really address that. And if someone wanted to challenge the validity of action taken with one half of a quorum, they probably would have a good argument. What do you think about that, Ben?
I fully agree with that. And what we're talking about here is really North Carolina specific, just to clarify. North Carolina law says that at your annual meeting or at membership meetings, really, if you don't get your quorum, you can adjourn the meeting until a later date, and that reduces the quorum by 50%. So if your quorum is 50% of members, which is unreasonably high, you can reduce it so you can eventually have a meeting. But the purpose of that is to have a meeting. It's not to send in ballots and somehow, if you don't get enough ballots the first time, send it in and you decrease your quorum. That's not the intent. So I think that would be hard to get a judge to agree to. So I would say if you're going to decrease the quorum, it really needs to be at a meeting.
And while we're on that topic, a lot of communities, they want to use the written ballot process in place of a meeting to have their annual meeting. And all we need to do is elect directors. Let's just not have a meeting. Let's just send out written ballots. Well, that's fine. But the problem is both the Nonprofit Corporation Act and the Condominium Act and the Planned Community Act all require that they say that the association shall hold an annual meeting, and written ballots do not constitute an annual meeting. So you still have to have a meeting. And if you don't want to do it in person, use Zoom or one of these other platforms.
Thank you. So we have the question, can a board hold monthly board meetings on Zoom even if the community has all the logistics and resources to do it in person?
Yes.
Okay. If you are going to use reserve funds for capital improvement, when the notice is required at the budget annual meeting, for example, if you're planning on capital improvements to a building with reserve funds, but don't yet have the estimated cost for the improvements, do you need to have another meeting to ratify this expenditure once the cost is firmer?
I would say yes. I mean, how can you propose a budget when you don't know what it's going to cost? And there's nothing that says that you have to wait to the end of the year or the very beginning of your fiscal year to hold a budget ratification meeting. You can call a budget ratification meeting in the middle of the year if you want for a proposed special project like that, a capital expenditure. It's just going to be a budget ratification meeting to ratify a budget for a capital expenditure. So I would just simply wait until you have all the numbers so owners know what they're voting on.
That's great. Thank you. So if a board makes a decision outside of a meeting with the written unanimous consent, does that item then need to be formally voted on at a regularly scheduled board meeting? And does that vote need to be in minutes?
Well, what I'll say is if they're taking action outside of a board meeting, if it's by email, those emails need to be kept as corporate records. They're no different than the minutes of a board meeting. They are evidence of action taken by the board outside of a meeting. Sure, it would always help if they vote to ratify it at the next meeting. Now, I understand sometimes action has to be taken between meetings and somebody's out of the country. They can't get unanimous written consent from all directors, but this decision can't wait. And I get that. That's the real world. And so they make a decision with the vote of 4 out of 5 by written consent. In that case, absolutely, at the next meeting, they should vote to ratify the action that was taken between meetings.
Thank you. We have just a couple more minutes, and I do encourage people, you can always reach out to your community manager with a question if we don't get to yours today. But we have another one on minutes, and it's asking, should we disclose in the meeting minutes who voted for or against an item so the community can see the voting record of the board members?
Well,
take that, Ben.
Yeah, the answer to that is it is not required in most cases. There's a technical procedure under Robert's rules where basically a board member could call a roll call, where you essentially keep a record of who voted which way. But unless an owner does that sort of special procedure, it's not required. Now, in some communities, I don't necessarily think it's a good idea, but you could, in your community, say, amend your bylaws to say that every vote will show the for and against votes and those who didn't participate. You could do that. I don't think it's a good idea, but that's the technical answer.
Thank you. We have a couple of questions about records. Does the board have to share items like a reserve study?
That's not, reserve studies are not on the list of documents that are required under the Nonprofit Corporation Act. That's really sort of a financial document. But my question is, this goes back into the secrecy thing. Why would you not share a reserve study with the owners? It's their money you're going to be spending. And I think owners need to see those reserve studies. So unless there's a really good reason to withhold it, even though it's not specifically required in the statute, I don't see any problem with disclosing that.
And it's not considered confidential, right?
No, it's not confidential. It's not dealing with any owner's personal information or sensitive or litigation related matters or anything like that. So, I mean, it's an estimate of what it's going to cost to fix things in coming years. That's all it is. Yeah. And here again, I'm a big proponent of transparency.
Yeah. I am too. I agree with you 100% on that, Mike. So as our final question, what happens if a person does share confidential information, such as forwarding an email that has something the attorney states?
You take that one, Ben.
Well, you just do what you can to contain the damage. Most attorneys are somewhat gracious to other attorneys, and they'll say, hey, your client forwarded this to me. I just wanted you to be aware of it. Now, some attorneys may not be so gracious if you're in active litigation, and they may say, well, this was disclosed. Now we can use it against them. A sort of a similar situation arises if, say, a private email string that was never intended to be public gets forwarded to the community, even if it's not necessarily attorney-client privileged. You just have to do what you can to contain it. And sometimes that may even be going to your members and saying, we apologize that this was disclosed. It was not intended to be made public. We certainly apologize, if it offended someone. You just try to do what you can to contain the fallout.
Hire a PR agency.
Well, Ben and Mike, thank you so much again for your time tonight, for your expertise and sharing it with all of us. It's always very beneficial. Do encourage people to go to the resources you provide. And we also encourage everyone to go to the recorded webinar. Some of your questions may be answered in another webinar that was held. Mm-hmm. So thank you. Good luck to you, and we will see you next month.
All right. Thank you for having us.
Thanks, everybody.
Bye.